appeal in the matter of Antonio and Secretary of State, part heard.
Yes.
My lords, we got to the end of ground 1 last night.
You did.
And we're proposing to proceed with grounds 2 and 3 this morning. One small point was I said I would reconsider one misstatement which my Lord Justice Warby pointed out. I shouldn't have used the word quashing the application order. All that happens in terms of remedy is the appeal is allowed. It's then left to the Secretary of State to follow on in the consequences of that. So I retract that, the use of that misplaced word as was picked up yesterday. So I move then to ground 2. Grounds 2 and 3, we've dealt with the way in which the ground G appeal was put to the judge, and I've dealt with my submissions on that. Grounds 2 and 3 now relate to the appeals under grounds C and E, under section 84(1).
Yes.
And I propose to begin by referring back to the way in which these grounds were put to the judge, which is in the supplementary bundle at tab 6. And it's my skeleton argument before the judge, and it's page 96 of the supplementary bundle. It's grounds C and E. And essentially there were 2 points in relation to the question of in accordance with the law, which arises under ground E and also as a component of the Article 8 analysis for ground C. The argument was that the decision was not in accordance with the law in circumstances where the appellant, the deportation of the appellant could not be enforced. And it was not in accordance with the law because it was inconsistent with the statutory scheme. That was the argument to the judge. And then the further point that arose only on ground C is that the deportation, the maintenance of the decision that the deportation order was required to be made by section 32(5) was not proportionate because given the fact he couldn't be deported, there was no public interest in maintaining the deportation order, and it was not the minimum means necessary of achieving the objective.
So both elements of this rely on could not be enforced, could not be deported,
yes,
and could not be deported.
Yes.
Right. Could not be deported anywhere?
Yes.
Could not be deported anywhere?
Yes, as the judge found. That's what I rely on in this appeal, the judge's own finding. There's no prospect of his deportation.
And that's, so you're saying at the date the decision was made, there was no prospect of the appellant being deported anywhere?
Yes, the position didn't change from when the decision was made until the appeal was heard. So the position was the same at the date of the decision and at the date of the appeal.
In what way was it the same?
At the date when the decision was made, which was in July 2013, the Jamaican authorities had already by that point confirmed he wasn't Jamaican, and the idea of removing him to Portugal had already been discounted.
Yes.
All that happened between 2013 and 2021 was a further elapse of 8 years in which those...
But why did you go from Jamaica and Portugal to anywhere?
The Secretary of State only proposed Jamaica and didn't find any alternative potential.
Well, Jamaica was referred to in the decision letter,
yeah,
but that doesn't mean that the only place to which the appellant could be deported was Jamaica. The Secretary of State might identify a different country of which it was, there might be evidence that your client is a national of another country, or that the position might change in respect of either Portugal or Jamaica.
The decision letter itself proposed Jamaica, notwithstanding that the end of the road had already been reached on that front.
Yes, but as we know, the destination country is not an integral part of the decision letter as per MS Palestine.
Correct, yes.
Depends what's in the removal directions.
So the nature of the appeal before this...
Anyway, your submission is, could not be deported anywhere.
Well, my submission is based on what the judge found, rather than I don't make a fresh submission on that front. So what the judge found is that 113 of his determination, which is page 55 of the court bundle, where he found there's no prospect of effecting deportation. So that's the finding on which I rely. And so it's in light of those findings that I say he erred.
And you say there he's referring to anywhere, not at that time just referring to Jamaica and Portugal.
Yes.
And that is your entire submission, is this in respect of both grounds 2 and 3, depend on paragraph 113?
Yes, or for that matter 111. But 111, I say, is a finding in relation to the concession, and then 113 is the overall finding, yes. And so it's in the light of the judge's own judgment that this appeal is brought.
Right.
As indeed, of course, it must be. That's the nature of an appeal against the judge's determination.
Thank you.
And so what I was taking the court to was the way the argument was put below.
Yes.
And at page 96 of the supplementary bundle, I explained at paragraph 16 the distinction between G and C, which we addressed yesterday, that under ground G it's about the removal, but grounds E and C are against the decision, which is a matter we've looked at that distinction yesterday. And then at 17, I submitted that in light of the respondent's resistance to the appeal, it's perhaps helpful to recognise allowing the appeal on these grounds would affect only a minor change in the appellant's position, and explained there that the submissions I made yesterday as to the fact that even allowing the appeal would mean simply that he would be granted some form of probably discretionary leave for short successive periods subject to restrictive conditions. And I set that out in the following paragraphs there. And then at 22 I addressed the in accordance with the law ground. And explained, as I did yesterday, that the phrase in accordance with the law in ground E is established to encompass breaches of common law and public law principles. That's the Abdi case that we looked at yesterday. And then the argument was put that the maintaining the deportation order against the appellant is not in accordance with the law on a proper construction of the statutory scheme. And then that submission was developed. And then the ground C submission is at paragraph 28, page 100. And at 30, the point was reiterated, if it's not in accordance with the law, then it follows Article 8 is breached. And then the further submission at 31 is that the decision is not necessary in a democratic society. In other words, it's not proportionate under Article 8. And the reason for that is that allowing the appeal against the deportation order merely opens up a route to living lawfully. If the prospect of deporting him reawakens because of some change of position, he may be subject to administrative removal, or potentially a new deportation order, as I explained again in submissions yesterday. I then alight on the well-known passage in Daly as to the contours of the principle of proportionality, including whether the means used to impair the right or freedom are no more than is necessary to accomplish the objective. And the submission is that in order to achieve the objective of removing the appellant from the UK, it's not necessary to leave him subject to a deportation order indefinitely. Depriving the appellant of the means of establishing a lawfully based existence in the UK pending the possibility of deportation reawakening is therefore inconsistent with the principle of minimum interference. So even if one assumes the continued intention or interest in removing him, the means of achieving that is disproportionate, where it maintains the deportation order, because it could be removed a minimal form of leave subject to conditions established in its place. And then at 32, over the page, I made the point 5 lines down that the respondent identifies no public interest in maintaining a deportation order that will not be enforced. And that the proportionality balance accordingly lay in allowing the appeal. So that was the ground C submissions made to the judge. The way the respondent addressed the submissions was by reference to the case of Art in Iraq, which concerned a ground C appeal by appellants who alleged that they were in a state of what was broadly termed limbo because they couldn't be removed, or that there was no realistic prospect of their removal. And so that violated their Article 8 rights, it was said. The judge adopted that analysis, and we see that in his judgment at 123 to 133. Now, I just note, first of all, that the judge put these submissions in the section in which he explained at 114 he was dealing with the with the ground G claim. So it's in the wrong, it's under the wrong rubric. So that's the first error. The way in which RA Iraq was decided was as a ground C appeal. The judge doesn't deal with ground C until after he's dealt with the RA Iraq arguments. So he misunderstood, and that's a further indication that he didn't appreciate the difference between grounds G and C. If we turn up RA Iraq, then we can see that's tab 19, which the Court of Appeal decided that. So you'll see in the head note it's an Iraqi national's case who alleged that he existed in a continued limbo status through lack of leave to remain, meaning he couldn't work, claim benefits, rent or buy property, claim NHS benefits, etc., and that infringed his Article 8 rights. The appeal was dismissed by the Court of Appeal and established what they said were 4 stages to the analysis of the limbo argument. This is under where it says under the holding. And so if we then turn to paragraph 11, the judgment of Lord Justice Haddon Cave, he sets out first of all the long case history, and then says at paragraph 11 that on the 20th of May 2013, the appellant filed a notice of appeal, raising 3 grounds of appeal, the second of which was that Judge Eschen had failed to consider the limbo ground. He submitted that whilst Section 84(1)(g) of the Nationality, Immigration and Asylum Act 2002 required the UT to consider the effect of removal from the UK following an immigration decision, Section 84(1)(c) of the 2002 Act required the UT to consider the legality of the decision to make a deportation order. So that distinction again. And then 12, 13, 14, 15 set out the ground C appeal. At 22, 20 is the heading, the decision appealed. And you see the single ground before Judge Allen was the limbo ground, which arose under 84(1)(c). So it was slightly different to the way in which this appellant put his case, who also raised ground E. Judge Allen found the appellant had no Iraqi passport, etc., and it appeared to be the case he was unreturnable to Iraq in line with country guidance 22, Judge Allen noted the appellant did not seek to argue the 2008 decision was not in accordance with the law. So again, that argument doesn't arise in RA Iraq. And then at 26, the grounds are set out, and 27 is a summary of the appellant's case, and then a summary of the respondent's case. We've got the legislation then at 30, and at 32, the point again is made as to the distinction between C and G grounds. And then at 35, there's a citation from the speech of Baroness Hale in the case of Kadir. At paragraph 4, she said, "There may come a time when the prospects of a person ever being able to safely return, whether voluntarily or compulsorily, are so remote that it would be irrational to deny him the status which would enable him to make a proper contribution to the community here. But that is another question." And then they reviewed the various previous cases that had looked at cases of problematic return. And then at 59 is a discussion of the authorities, and they pick up on what Baroness Hale held there. And at 60, note that the authorities acknowledge the theoretical possibility of a state of limbo giving rise to a breach of Article 8 rights, but it's striking that there's no domestic case in which such a limbo argument succeeded. And the only known example is Mendizabal v France, which involved two singular features, an exceptionally lengthy period of limbo, namely 14 years, and no question of the claimant being returned to Spain. And then they set out, Lord Justice Haddon Kay set out at 63 onwards, the 4 stages which he considers should be applied to a limbo argument. And he says, first of all, distinguish between prospective limbo and actual limbo. Actual limbo is where a deportation order has in fact been made. This is the end of paragraph 63. There will normally be no leave to remain, and the individual will be unable to work, claim benefits, or receive more than basic GP care under the NHS. This may be described as actual limbo. And then stage 2, the prospects of effecting deportation must be remote. And he says 3 points there. First, it must be apparent the appellant is not capable of being actually deported immediately or in the foreseeable future. 2, second, it must be apparent there are no further remaining steps that currently can be taken in the foreseeable future to facilitate his deportation. And 3, third, there must be no reason for anticipating change in the situation, and thus, in practical terms, the prospects of removal are remote. And in fact, the judge echoes that in his judgment on 111 to 114. And he says, if those criteria are not satisfied, a challenge to an otherwise lawful decision to deport or deportation on the basis of limbo, calling into question whether the public interest in deportation should be overcome by considerations of family or private life or other convention rights, is likely to face formidable or potentially insuperable obstacles. There's then a fact-specific analysis, setting out the nature of the conviction, etc., whether the impossibility of achieving deportation is due in part to the conduct of the individual, e.g. in not cooperating. And then stage 4 is the balancing exercise. And this will involve an assessment at 69 of whether the individual remaining in a state of limbo or prospective limbo will have an impact on the individual's Article 8 or other convention rights, and if so, the extent of that impact, and how far that impact is proportionate when balanced with the public interest in the decision to make the order or to sustain the same. And then these are perhaps the key passages for the appeal today, 70 and 71. Public interest in question is principally the public interest in maintaining an effective system of immigration control and in deporting those who are in the UK illegally. There's no separate public interest in preventing such individuals from, e.g. working or relying on benefits or gaining the full range of free healthcare. That very much echoes the submissions made to the judge. Parliament has, however, decreed by statute that such benefits and opportunities are to be withheld from those here illegally. Parliament must be taken to have intended that the lack of such benefits and opportunities will form a disincentive to coming or remaining here illegally. And then 71, the principal basis on which it might be said that the public interest in continued limbo may be so weakened, such that Article 8 rights or other convention rights might tip the balance, will normally only arise in cases where it's clear that the public interest in effective immigration is extinguished, because in practical terms there's no realistic prospect of effecting deportation within a reasonable period, see above. So on those, on the basis of those, the appellant didn't heavily rely on this because the submissions were put in a different way, but they were addressed, and the respondent picked up the point. So then I turn to how the judge dealt with them at 1, 2, 3 onwards. So at 1, 2, 4, he says, as a starting point, I conclude actual limbo. Clearly that's correct, as opposed to prospective limbo. And then in regard to stage 3, he says, the appellant has not shown any of the time he spent here was lawful, either with leave or as an EEA citizen. He's not established any family life and little evidence of private life, given that he can't work or undertake business activities. He has relationships, and taking those, in case of his highest, he has no family in the United Kingdom. His offences are very serious. He's been in the United Kingdom for an extensive period at 127. Attempts to document him have now taken well over 10 years. I accept that any prospect of effecting deportation is remote on the basis of the evidence before me. So that's applying the test in RA. Under stage 4, I'm required to undertake a balancing exercise. In this case, the starting point for assessing the public interest in removal is very high. The appellant was sentenced to 9 years imprisonment. He has not, I accept, been convicted since his release. But that's not a matter that diminishes to any significant extent the public interest in deporting a criminal whose crimes are of such a magnitude as those. The analysis at this stage involves an assessment whether the appellant has been cooperating with obtaining documentation. That in turn involves assessing his conduct in providing information. For the reasons set out above, I'm not satisfied that concession notwithstanding, he has been candid or that he has told the whole truth about his background or nationality. These are factors I take into account and which I consider militate against him, and accordingly I consider he is in effect responsible for his situation. 130, taking all of these considerations into account, I consider, given the very strong public interest in his case, given the seriousness of the appellant's offending, that the public interest is not so weakened that the decision under challenge was disproportionate. In reaching that conclusion, I've taken fully into account the limited basis on which the appellant would or could be permitted to live in the United Kingdom as submitted. I accept he may not be able to work or have access to benefits and all the other possible restrictions identified. And then he says, and then rejects the analogy with many Zarbel. And then over the page at 131, he therefore rejects the decision under challenge as being wrong under grounds 84(1)(e) or G. So we can see the judge misunderstood the nature of the grounds. So that's the first point. But then turning to the more substantive point, at paragraph 127, the judge sought to equiparate this case to RA Iraq, where there was some prospect, albeit remote prospect, of removal. But the factual difference between this appeal and RA Iraq is the judge's own finding of no prospect of removal. And that's crucial in this particular case because it means that the public interest in maintaining effective immigration control by deporting the appellant is extinguished, to use the phrase of Lord Justice Haddon Cave at paragraph 71 of RA Iraq. And so my submission is that consequently, paragraphs 128 to 130 and 130 of his judgment the judge erred in giving what he found to be a very high, giving weight to a very high public interest in the removal of the appellant. Because, does that make sense, my lord?
Well, he says in paragraph 127 that he accepts that any prospect of effecting deportation is remote.
Yes.
So he's putting this case into that category.
That's right, and that's what I say is an error, because his own finding at 113 is of no prospect of removal. He's then looked at what it says in RA Iraq, which was a case of remote prospects of removal, and says, fine, well, we're in the same box as that. But that's the error of translation.
Right. So you say that 113 is in conflict with 127.
Well,
113 of his judgment is in conflict with 127, and that 113 should supersede.
It's not in direct conflict. The prospects are at least remote, but it's actually a distinction of some significance that he found not only remote, but also no prospect. Whereas RA Iraq didn't contemplate the question of no prospect. And so when he's applying his mind to the RA Iraq analysis, it didn't occur to him that there was a distinction of some significance there. And the reason it's of significance is that if there's no prospect, then there can be no argument that there's a public interest in deportation. It's not simply that the public interest is reduced in weight, it's that it's extinguished.
I think, if you forgive my saying so, I think aren't you reading rather too much into paragraph 71 of RA Iraq? I mean, what Lord Justice Haddon Cave, as far as I can see, is saying, well, the public interest may be so weakened such that the public interest is extinguished. It doesn't say if there's no prospect, there will be no public interest. He's not saying that, is he?
What he's saying is where there's no realistic prospect, so where there's a prospect, but it's distant, it's remote, as to use the judge's words, then the weight given to the public interest is weakened. That's entirely understandable. So you reduce the weight in the overall balance because the prospect is remote. But what I'm saying is here goes a stage further. Where you cannot deport, then what is the public interest in maintaining a deportation order? There can't be a public interest in maintaining an order that can't be enforced. And so the situation is qualitatively different to one where there is some prospect of it being enforced.
Well, I understand that's the argument, but it doesn't seem to me that it necessarily flows from what's said in RA Iraq. You're saying this is a different case.
Indeed. So the judge mistook the situation by purporting to apply RA Iraq, which is about remote prospects of removal. On his own findings of fact, it wasn't proper to try and translate that, because if this had been an RA Iraq case, he could properly have said, I give very high, very significant weight to the public interest. But this is not an RA Iraq type case because it goes that stage further. And in that circumstance, there is no public interest in maintaining the deportation order. So that's what I say is the error of law. Now, in terms of the remedy, if the court is with me on this ground, because what needs to be done is to re-evaluate all the factors, bearing in mind no public interest in deportation, I would submit that the preferable option here, but on this ground only, would be to remit to the tribunal for it to reconsider in light of all the factors. I'm going to pause on ground 2 there, because under ground 3, this distinction between some prospect and no prospect also comes out of the case law that I'm going to go to, but we can tie that back in a moment, rather than go through reams of it just to get that singular point. So I turn to ground 3 unless there's any more concerns as to ground 2. Ground 3 is articulated as the judge's error in relation to ground E and C and the Article 8 balance, that maintaining a deportation order that cannot be enforced was in accordance with the law. So, as I've shown, the contention was that it's not in accordance with the law to maintain the decision that Section 32.5 applied, for duty to make a deportation order. I've set that out. I've shown the skeleton argument below. The judge didn't give any distinct consideration to that ground. As we've seen, he dealt with the ground G appeal from 114 to 132, and then at 113 he turns to ground C. So at 114 he turns to ground C and says, essentially for the same reasons, and he says that essentially what the appellant seeks to do under this ground at 136 is to challenge the legality of the making or maintenance of the deportation order on the basis either that the order is being used for an improper purpose because it cannot be carried out, or is inconsistent with the statutory scheme in place following the implementation of the 2016 Act and the replacement of temporary admission. So you can only be on immigration bail. I do not accept that such a case can be made under this ground given its narrow scope. Further, even were it arguable within the scope of the grounds, I'm not satisfied it's made out in any event. So he doesn't actually address the ground E appeal as it was made to him. That is a technical error. See, I've cited in the skeleton argument the case of Iran against Secretary of State, paragraph 84, but we don't need to turn that up. So here, under the ground E appeal, we have the same point which I explained yesterday, that where a decision is in breach of established principles of public law, it's not in accordance with the law. That's the Abdi case that I took you to yesterday. And ZH Tanzania is helpful on that too. The place the judge probably did deal with this point is at 122, where he says, as part of the ground G case, admittedly, but he says, I do not accept that maintaining a deportation order that cannot be carried out as an improper purpose. They are imposed and endure for many reasons, not just to require departure from and prohibit return to the United Kingdom. They express the public interest in removing foreign criminals. And that's clearly part of the policy expressed in Section 117C, the 2002 Act. So I say that's the first error in the way in which he addressed these submissions, because it's plain that on a proper construction of Section 5 of the Immigration Act 1971, the purpose of a deportation order is to require a deportee's departure, not to regulate their stay or for any other purpose. There are not many reasons. The second error is then in relation to the judge's understanding of the statutory scheme, and this arises in particular from paragraph 139 of the judge's determination, his understanding of what's explained in the Kaiti decision. He says, as both parties accept, Kaiti is under appeal, so when it came before him it was at first instance, that's since been upheld by the Court of Appeal. Unless and until it's overturned, I consider it's good law, whether or not strictly binding on me. I find no good reason not to follow it. Applying the proposition set out at the end of the decision of Mr. Justice Lang, as she then was, I conclude, even in this, if this issue were in the scope of the appeal, the decision under the appeal was in accordance with the law. Now, what the decision in Kaiti is about is the statutory scheme, in essence, and the proper application of that is that where there's no prospect of being removed from the jurisdiction, then a person may not be maintained on bail. And the reason for that is that a person can only be on bail where they can be detained. And they can only be detained pending removal or deportation. So the submissions made to the judge were accurate, that while a deportation order is in place, a person can only be on bail. I showed you yesterday, Section 5 makes a grant of leave incompatible with the deportation order. Section 5 of the Immigration Act 1971. But it's inconsistent with the scheme to maintain a person on bail who cannot be detained because they cannot be deported. And so the judge should have held that where there's no prospect of deportation, the power to detain the person doesn't exist. There's no power to maintain the appellant indefinitely on bail. And so the impulse of the statutory scheme is that the deportation order itself is not in accordance with the law. So I explain that then by reference to the judgment in Kaiti, which is our tab 20 in the authorities bundle. So in Kaiti, the appellant had been on a restriction order for many years and then on bail for many years. And the argument for the appellant there was that a grant of bail was a corollary of the power to detain. Where he could not be detained, for example, in the event of a breach of bail condition, he accordingly couldn't be held on bail either. So he had two lines of challenge. One was that if a power to detain existed but couldn't be exercised, he shouldn't be on bail. And the other was if the power did not exist, he shouldn't be on bail. The argument that if it didn't exist, he shouldn't be on bail was conceded by the Secretary of State and was common ground at both stages of the case, both in the High Court and the Court of Appeal. And the reason for that was that the case applied the judgment of the House of Lords in Kadir, in which Lord Brown had distinguished between cases in which there's a subsisting jurisdiction to detain and because there's at least some prospect to do so, and cases where there is no prospect of removal and no prospect, and therefore no power to detain at all. And these are quoted page 482 of the bundle in paragraph 83 of the judgment in Kaiti. I just ask the court to read the passage from Kadir that's cited at paragraph 83.
Yes.
So in Kadir, the argument was essentially the same as it was in Kaiti, but it related to the preceding statutory scheme. Mr. Kadir was on something called temporary admission, which was similar to the status of being on bail now. And his argument was, because I can never be removed, it's inappropriate to leave me indefinitely on, or unlawful to leave me on temporary admission. I should be granted leave. Because I can't be detained, and therefore the temporary admission regime only applies to those who are who can be detained. What Lord Brown says is people who are still liable to detention because a power exists, even if it can't be currently exercised, can remain on temporary admission. But where you reach a situation like that in Tante Lam, which he cites, where in that case, as you see at B to C, it was effectively conceded that removal was no longer achievable. Once that prospect had gone, detention can no longer be said to be pending removal. That's the condition to the exercise of the power of detention. And therefore, the power ceased to exist. So Kaiti made, so then the key passage then in the Kaiti judgment is 148 to 149. On page 496 of the bundle. Kaiti has sought to amend and sought permission on ground 2. The judge found it had no prospect of success. And the reason is the law requires there to be only some prospective removal of the appellants at some point. Mr. Tam accepts on behalf of the respondent that if there were truly no prospective removal, then, even in accordance with the House of Lords decision in Kadir, there is no legal power to detain at all. Once that point is reached, if it is, then he accepts there is no power to grant bail. But on the material before the judge in the case, that point wasn't found in the decision below. And then at 149, Lord Justice Singh says, true it is, there's further material which the appellant seeks to place before this court, which postdates the decision in the High Court case, but rejects the case nonetheless. And so permission wasn't allowed to run that additional point. But the legal situation is conceded by the respondent, and quite properly on the basis of Kadir, is the one that I invoke in this appellant's case. And so my submission is that the proper finding was that here, given the judge's determination that there is no prospect of his deportation, that this is a Tanzania type situation where he can't be removed, there's not even some prospect. And so in those circumstances, he can't be detained because the powers to detain in Schedule 3, to which I took you, are powers pending deportation. Deportation is not pending. He can't be detained, then he's not liable to detention. And you can see that in Schedule 10 to the 2016 Act, which is at tab 6 of the Authorities Bundle, page 88.
Yes.
Paragraph 1, subparagraph 2 of Schedule 10, the Immigration Act 2016, says the Secretary of State may grant a person bail if the person is liable to detention under a provision mentioned in subparagraph 1, and then it sets out the various powers that the Secretary of State has for detaining non-British citizens, and that includes at B, the persons being detained under paragraphs 2.1, 2.2 or 2.3 of Schedule 3 to the Immigration Act, detention pending deportation. So the power to grant bail is dependent on the existence of one of those powers to detain. In turn, those powers are dependent on the ability to deport. There being no prospect of deportation, those powers do not exist, and therefore the power to grant bail doesn't exist. And so the submission below and the submission I repeat here was that it was not in accordance with the law to maintain the deportation order, whose only effect is not to achieve deportation, its actual purpose, but to inhibit the proper regulation of his stay in the UK, because it stands in the way of the proper regulation of his stay here, which would be a restricted and conditional form of leave, not bail. that being the only alternative to bail, incidentally, in the legislation now. And so the appeal should have been allowed on the in accordance with the law ground too. So on this ground, I submit the court can decide the point for itself. It's a point of law. There's no need to remit this point. So it would only be a question of remitting to the tribunal if I succeeded on ground 2, but not on grounds 1 and 3. And so I finally just go back to the overall purpose of the legislative scheme and contemplate what, for a moment, the contrary position is if this appeal fails. Because this appeal failing, subject of course to any unlikely further appeal, is effectively then the end of the road for the appellant. And so he will live in the UK. The deportation order ceases to be suspended once this appeal is concluded. So the deportation order requires him to leave the UK. It cannot be enforced. And effectively he spends an indefinite further period, therefore, potentially without end, subject to that deportation order. And that is simply not consistent with what is contemplated as the purpose of the legislative scheme. The deportation order is not designed as a mechanism for regulating a person while they are remaining in the United Kingdom. There are ample and very restrictive powers open to the Secretary of State to regulate the continued presence of this appellant in the United Kingdom. And so my submissions are entirely consistent with the intention and purpose of the legislative scheme. And that reinforces, in my submission, the ground of appeal that it is not in accordance with the law to maintain a deportation order that can't be enforced. And that's my submissions on ground 3. Unless I can help any further, that's the case for the appellant.
Thank you. Any questions? No, thank you very much. Thank you. Yes, Ms. Anderson.
My Lord, to aid the swiftness of the hearing, I have taken the opportunity overnight to do a short speaking note which gives the references. So hopefully that will, it literally tracks the submissions and doesn't add anything new in. So it should help with note taking.
And Mr. Goodman's got one.
I have, yes.
My Lords, I do propose just to literally deal with the submissions that have been put to you in the order they were put.
Yes.
If there are any additional sort of matters that come up or questions, then of course do take me out of line. But if we can just sort of dive straight in with ground 1. This, you'll remember, is the section 84(1)(g) ground. I've summarised it in the speaking note to what the point is, and I've just taken the point that, I mean, it's no doubt my error too, but I hadn't fully perhaps understood the full import of the point previously.
No,
so here I set out
our response.
The response to it. Taking those points in turn in paragraph 4, the major point is that it's section 82, which we have in the authorities bundle, which defines the, if we can just pull up tab 4 at page 61, it's section 82 which defines the right of appeal here.
Sorry, hold on, you're taking us to section 82.
Yes, in tab 4.
Yes.
And it's actually page 61, which we turn over. But if we look at 82 on page 60, you can see this is what defines the right of appeal, the decision that you're appealing against, the immigration decision.
Yes.
On 61, subsection 3A page 61, you can see that 2J does not apply to these automatic deportation appeals. So there's a distinction there. And Parliament has specifically provided what the immigration decision is in an automatic deportation case. And it's given it a limited definition that if we look into what it says that a decision that Section 32 applies is an immigration decision. So that's the decision that you appeal. It's not the decision to make a deportation order, which is J ordinary.
Yes, it's
this
that Section 32.5
It's modified,
applies.
so it's a bit of a decision
Yes.
to make a deportation order. It's not the whole of the decision,
Yes.
as it were. B, you can see that a reference to an appeal against an automatic deportation is an order. Is a reference to an appeal against a decision under Section 32. So they've really sealed it up here. There's no way out of this, that what's under appeal is the Section 32.5 decision. We know that the Section 32.5 decision, I won't go over all the provisions because we looked at them yesterday, but we know that's effectively a Section 33 decision because the only exception that could apply here is Exception 1, which is in Section 33. And that is in the third bullet point, actually, I'll put it there, where the removal, it's a sort of state of being, as it were, it's where the removal of the foreign criminal in pursuance of the deportation would breach a person's convention rights.
Yes.
So the first point to make is that it's Section 82, not Section 84, which defines the scope of the appeal. So you can't bring something in through a ground of appeal which isn't in the decision, and that's essentially one of the points that I think is really being made in MS Palestinian territories. That the right of appeal here is about the 2013 automatic deportation regime decision, and really what's at stake is whether there's a duty to make a deportation order. Looking at the third bullet point, I've just pointed out the terms. The fourth bullet point, if Section 33 applies, you can still make a deportation order. So some of my learned friends' submissions go to whether you can make a deportation order or not, but that isn't what this appeal is about. And that's an important distinction because I'm coming to whether you should be treating Section 32.5 cases sort of differently anyway. They're sort of sui generis in a sense compared to the other grounds of the other forms of immigration decision. If Section 33 where Section 32 specifies that the appeal does concern the type of immigration decision that one might think logically entails removal, and that was the H type of decision, the 2H we looked at yesterday. It might help if we just look at Section 82. So if we go back to page 60, you can see there that the rights of appeal, there was a right there. So the type of decision under 82.2H was a decision to remove, as it were, that they be removed. Even in that context, in MS Palestinian territories, this court said that doesn't entail considering removal directions and removal. So even in that context, you can't shoehorn the removal directions and the removal part into that type of decision. So the gap my learned friend really has to fill is how do you shoehorn that into a Section 32.5 decision? Now he says...
When you say how you shoehorn that, how you shoehorn...
His essential argument that when one looks at the 32.5 decision,
Yes.
you necessarily contemplate removal.
Yes.
And removal means that you've got to see, could you lawfully set removal directions?
Yes.
And here you can't because Jamaica isn't the country of nationality and so on and so forth. So all of that, because you can't, a lot of these submissions run along the lines of, because you can't carry it through to the end and actually remove someone with removal directions, then it's unlawful, not in accordance with law. You go right back to... What I'm saying is that sort of reverse logic reasoning doesn't work because the court says you look at the Section 82 immigration decision and you say that contains this, and it doesn't contain, the removal question in the sense of affecting practically removal. We'll come on to, I'll show you what the court does in MS Palestinian territories about how you sort of deal with the word removal where it comes up. But you can see that.
So your submission is it's a pure analysis on whether Section 32(5) applies, and that it's that which is being challenged, not the consequences which might follow from the decision that Section 32(5) applies.
Yes, that in MS Palestinian territories, the court very clearly resisted expanding an immigration decision to take account of all the practical and legal and other questions that might arise in connection with that decision or in connection with removal.
Because you're then seeking to appeal something that hasn't yet happened.
Yeah, just because the word removal is in there, it doesn't bring in, it's not strong enough to bring in all these other complications. You actually look at the decision. And
but
here,
what you're submitting is that you don't bring in the later stages of the procedural process when looking at the Section 32(5) decision.
Yes, the essence of my learned friend's argument is you have to look at the Immigration Act and the schedule to the Immigration Act that deals with removal directions and say, could you lawfully issue removal directions under that schedule, which are actually termed, when you look at the schedule, it's administrative provisions, to deal with removal. And in my submission, it's very clear on the authorities that you simply do not do that because the word removal is somewhere in the mix. And that really is what's been found in, even in the context of H. You can see in H the word removal is actually...
Sorry, you were taking us... H, yes,
H,
sorry, go on.
Going back to H to say that even where it's actually all about removal, in a sense, or much more closely connected with removal, that it's not strong enough. So my learned friend can't do that just by having the Section 33 consideration of whether removal of a foreign criminal in pursuance of a deportation order would breach convention rights. And I'll come on to how we can fit that in. MS Palestinian Territories is very helpful in dealing with these points. Because although it is on a different section, and as I'd say, a much stronger case, one might think, under H, you'll see the court doesn't support any of this type of analysis. So the first point to make is that my learned friend has sort of got to make this bridge. There's no authority that makes the bridge for him. And there's actually nothing in the statutory terms that help. Because when you actually look at Section 84, which is the way he's getting it in through the 84 1G ground, you'll see that even in Section 84, which we have a few pages on, page 62, we look at 84 1G, and...
Sorry, hold on. 84 1G, yes.
Yes. And the submission is that because this talks about the removal of the, that's why you're looking at removal directions, etc. But what it says there is that the removal of the appellant from the UK, in consequence of, and it's that from I want to emphasise and bear in mind. So it's not talking about destination. It's not talking about to. It's not talking about that. It's talking about the aspect of perhaps what's more clearly associated with deportation, or is that you've got to leave the UK and you can't come back, as it were. So it's being excluded from the UK rather than destination of any enforced removal if a person doesn't obey the deportation order. So coming on now to MS Palestinian Territories at tab 11, these points are sort of helpfully dealt with by the court, albeit in the context of what might be said to be a stronger case of H. So picking it up, my lord, it's at page 207, paragraph 22. I won't go over the case because you saw it yesterday, so I'll just pick up the points that I want to emphasise.
Sorry, where are you taking us?
In MS Palestinian Territories, tab 11. We are familiar with the case, so I'm just saying that I'm not going to sort of reacquaint you with it in that sense. I'm just going to pick up the paragraphs, but if it becomes incoherent, do stop me. So page 207, paragraph 22. The first point to make is it's very clear that the court there is saying you look at section 82 to get the scope of the appeal. You don't look at the grounds of appeal and then work backwards. So they look at the language of Section 82H in that case and say it doesn't support the argument that the proposing of a destination country is an integral part of the immigration decision, and that's a necessary link that my learned friend has to get in my submission to the Section 32(5) appeal. So you can't do it, as I say, reverse by looking at the grounds of appeal. If you then go on to paragraph 24, you can see that the court makes this point.
Sorry, paragraph
24
24,
on page
thank you.
207.
Yes.
Looking at the language, in that case of H, but it applies in our case, that the decisions referred to in Section 82, the person removed from are all decisions that a person is removed from the UK. None refers to destination. So what the court's saying there is that if what you're considering is removal from the UK, you don't import into it. There must be a destination country in contemplation, and it incorporates questions about destination. So the court sees that as a reason why you don't make destination integral to the right of appeal, even in Section 82(h) case where it refers to removal. And that applies here because the section my learned friend wants to get this in under is 84(1)(g), and that's clearly a removal from the UK section. Then if we go on to paragraph 25, the next paragraph, even in that H context where there's reference to directions, removal directions, it doesn't mean that the immigration decision itself must comply with the requirements of the 1971 Act. And that's really my learned friend's argument, that because you can't comply with those requirements, because you haven't got a country of nationality or a country where you believe that someone's liable to be accepted, you can't make a lawful set of removal directions. And so the court rejects that logic too there in paragraph 25. And that's another reason why here you shouldn't be sort of adding language into 82(3)(a) appeal right to say not only is it an appeal against whether Section 33 applies, but it's also appealing in a sense, or getting the court to assess whether lawful removal directions could be made. That's not part of the appeal. It's not part of the tribunal's job to assess the lawfulness of making removal directions to a particular destination. So the judge can't be faulted for sort of not doing that, as it were, because it's just not part of the appeal.
Because again, we haven't got there yet.
Yeah, we haven't got there yet, and so a lot of his submissions he's got it wrong under 84(1)(g) because he hasn't gone through this process and hasn't looked right to the end and hasn't said, well, could you lawfully make removal directions under the schedule of a 1971 Act that does it. So that there can't be a material error in that because it's just not part of the immigration decision that was under appeal. And the final, the next point, sorry, is the final conclusion is in 26 in this case, that a person is not an illegal entrant but has refused to enter. Sorry, my lord, that the point I want to make is the point that's there in the third bullet point on page 3, which is Parliament is unlikely to have intended that the proposing of a destination country should be the integral part of any immigration decision. And this is on page 208 at the end of paragraph 26. I don't think we need the beginning bit because it's about age. But you can see that the court in 26 says we don't think this has anything to do with H, the H type of appeal. But they also go on to say those reasons are other reasons why Parliament, is unlikely to have done this with any of those types of immigration decisions.
So you say this case applies by analogy to Schedule 3?
Yes, under the
Directly, perhaps.
yes, under the 3A type of appeal.
Yes.
I mean, that word says any, that
Yes.
and really what the court's saying is we're looking at the role of the immigration decision and the appeal against the immigration decision, and we're saying that even if removal is mentioned, even if there's that, it doesn't mean you have to look all the way down the line on the basis of whatever hypothetical circumstances there are at the time, and say that if at this moment in time it wouldn't be lawful to set removal directions to a particular destination, then you can't actually make a deportation decision, or you can't do what any of those immigration decisions are. What the court's effectively saying is make the immigration decision, and then at each stage, the consequence can be challenged.
Yes.
You don't have to roll all the
Yes.
consequences up.
Yes. Well,
So-
also that submission depends on the assumption, seems to me, possibly, that when the removal directions, if and when removal directions are given, they will be in respect of Jamaica.
Yes.
And that hasn't happened.
Hasn't happened, my lord, and I'll
And-
come on to
okay.
those types of points with the judge's findings.
Right.
They fit into
Okay.
sort of later
Okay,
points, but
thank you.
absolutely. And that's got to be, and that's really one of the, in fact, it might really be the court actually comes onto that even in MS Palestinian territories, because it does say that, in fact, it's the last point on page 3 of my note, and it refers to paragraph 32 of MS Palestinian territories, where in effect the court says those types of things, because it's what's summarising what's said there is the court says, well, look, there's lots of complications in practical and
Yes.
legal senses, etc., that might occur, and that's the reason why it's very unlikely. Parliament says you have to be sure of all that before you make the immigration decision in part. And if you look at the full, I won't read out the full paragraph 32, but you see it covers that. And what's also important to take from that is that the court also says that when you're looking at what the Human Rights Convention question is, and that does include removal from the UK, as it were, you don't then, in that human rights question, have to incorporate all these practical and legal problems of setting removal directions and what have you. What you're really looking at is a protection claim, is that the sort of more ordinary case where you see someone who says, I'm entitled to international protection because my country of nationality. If you remove me to my country of nationality, I will be tortured, or I will be... So that's the type of question that's really being considered when you see that ECIHR question being posed, and that's a Section 33 question, is let's get an asylum claim out of the way, or let's get a human rights claim
Yes.
out of the way.
Yes.
If you can.
Yes.
It doesn't say look at every possible problem you might have
Yes.
with removing someone.
Yes.
So that's really what paragraph 32 says. It's just inappropriate anyway, and very unlikely Parliament would be making it as difficult as that. And you don't need to, because, as I say, at every stage, if there is a ground to challenge, you can do it at that time on
Yes.
the real facts.
Yes.
You don't have to have this sort of hypothetical
Yes.
projection forward. And just here, just a note that in this case, it isn't one of those cases where the nationality is clear, the risk is clear in the country of origin, everything's clear. So you're perhaps more likely to be able to say there's no prospect ever. I'm not saying you can, but I'm just saying, it's more. This is a situation where you don't even really know the true nationality. You don't really know. So it's far from the type of scenario in which you could make accurate and certain sort of statements like there will never be a prospect of deportation anywhere. But I'll make that good with the judge's findings, my lord, too, when we come to it, because it comes into a lot of these points sort of mesh into each other in different ways. So I'll take them as they naturally come up. So just to go back to the UT decision on this point, and this is page 4 of my note, the UT correctly directed itself as to the scope of this appeal. So if we can turn up the decision in the core bundle, page 44, you can see that at paragraph 61,
Sorry, hold on. Yes.
that's where the judge very clearly sets out that this is a 3A appeal. So he knows that it's not he actually states this in terms, but he's correctly directing himself as to the law, as to which bit of Section 82 applies and what the type of the appeal is. And then if we go forward to page 59, paragraph 134, you see the judge states it in terms. It's important to bear in mind the decision under challenge. It is a decision that the appellant is a person to whom Section 32(5) applies, and it's not in dispute, but you're in 32 territory. And so the only exception is the exception 1 in 33(2). And he really makes a very clear distinction. The immigration decision in question is by operation of 82(3)(a), not the decision to make a deportation order. So it's a sort of very, not necessarily a narrow decision, but it's a very specific type of appeal here. And as I say, that is important when it comes to this trying to import through 84(1)(g) into that decision an integral destination of removal and all of those points. So this is not a general sort of judicial review of all things related to removal, which in my submission is really what you need to find in order to start to look at the schedule to the 1971 Act. The final bullet point, is that I don't think this was pursued. It's the further points under the first ground of appeal that my learned friend made in his skeleton at paragraph 19 about proportionality, saying the judge didn't consider proportionality. I don't think he's pursuing it, but just in case he is, I've just quickly indicated there that, however it's set about, as it were, the judge did consider this idea of removal and return. So you remove from the UK because you haven't had your nationality established, etc., in the identity in which you've been removed. You're rejected by Jamaica and you come back again. And he did look at that to see whether the interference with the individual's rights would be essentially disproportionate. And he certainly made a finding that would be minimal, and that's a reasonable finding. So insofar as the sort of paragraph 19 of the appellate skeleton argument point is pursued, in my submission it's not a good one. So finally, I just want to make the point that's on page 5 in the final bullet point of paragraph 4, that if this court was asked to make its decision, because I think my learner friend is asking you to, in the event that the judge didn't do it properly, as it were, to do it yourself and to actually make a decision under this ground. In my submission, if the court were to do this, it should refuse anyway, because ultimately this is still an argument about a convention ground. The convention ground is Article 8, and the parliamentary requirements in respect of Article 8 in deportation cases are very clear. And so if one was talking about proportionality, which is the second point, or generally whether there's a breach of a convention right, which is what Section 33 ultimately looks at, in my submission, there's just no possible basis in this case for finding that there would be a breach of a person's convention rights. And on the approach that Parliament mandates to be taken. So it's a sort of overarching point, but it's to put the case in context, particularly if the proportionality point is in play. So moving on to the second ground, as say under the second and third grounds, I will bring in the decisions and the particular bits of what the judge did find.
So, sorry, just summarising your submissions in respect to ground 1, you say this is Section 32(5) appeal.
Yes.
So the question is whether the grounds for, excuse me, making a deportation order under Section 32(5) are satisfied. That is subject to Section 33. Section 33 states, exception 1, that section 32(5) doesn't apply if where removal in pursuance of the deportation order will breach a person's convention rights.
Yes.
And then 7 says the application of exception does not prevent the making of a deportation order.
Yes.
Um,
So it's not really about even the making of a deportation order. What it's about is this one of those cases where Parliament has said you have to make a in the first instance you have to make a deportation order. It doesn't mean it can't be revoked. It doesn't mean that things can't change, etc. But is it this category of cases? So if it's been shown, effectively there would be a breach of a convention right, then that is a ground for saying no, this takes it out of the mandatory
yes.
situation. So if it was proven that, as I say, there's a sort of permanent situation or something
Yes.
anyway,
yes.
then that's a way of relieving the
Yes.
obligation.
Yes.
That's as far as it goes.
Yes.
It's not go all the way to the schedule that concerns.
No, I understand that. I must admit, despite the authorities we're talking to, I'm not sure I completely understand subsection 7 when it says the application of exception doesn't prevent the making of a deportation order if you find that the removal in pursuance of a deportation order will breach a person's convention rights.
I think that sometimes there are, in order to prevent technical appeals and technical
Yes.
arguments and what have you, sometimes things are put in to clarify so that relationships aren't built up between it. And one of the imperatives here was to separate the appeal system and the from the making of a deportation order.
Right.
Because what was happening was that foreign criminals were sort of being released while all this was going on and deportation orders were being made. But you couldn't make a deportation order until you'd gone through the appeal
Yes.
system and what
Yes.
have you. And so there was this big gap
Yes.
sometimes of not having someone even required to leave. And if they
Yes.
did leave, you couldn't necessarily stop them coming back.
Yes.
So Parliament's sort of concern was to get the deportation order in place.
Yes.
It doesn't signal the end of everything in
Yes.
that sense.
Yes.
But what it does is say, because you're convicted of these crimes,
Yes.
as matters stand,
Yes.
you should be leaving.
Yes.
And clearly, if there's a sort of obvious convention basis not to require you to
Quite.
do that,
And you can
then
still challenge the decision on the basis that it would breach
yes,
your rights, but that itself doesn't stop,
doesn't stop
the making
of
of
the
the
deportation order.
yes.
So that bit's done,
yes.
and then, as I say, everything. So it's
Yes.
just a detached.
Partly because it
decouple.
would be assumed that the Secretary of State would not make a deportation order if he or she was satisfied they would breach convention rights.
If they were satisfied, yes.
Yeah, but
As
that's-
we know.
I know that's a right. Yeah.
Yeah,
Okay.
as we know, sometimes that's the hotbed of dispute.
Yes.
as it
No,
were,
I understand that.
and-
And so,
But
thank you
there
very
are
much.
cases, of course, where
Yeah.
that might be so, and it's just to sort of dip those out, and really it just puts it back into the discretionary
Yes,
area
right,
and
right.
takes it out of automatic deport.
Sorry,
Yeah.
I just have one question. You've made very clear what you submit is the scope and what are the limits of the ground G appeal. And I've remarked, I think yesterday, that there's a similarity of language between that and subsection 2A of section 33. Do those submissions about G apply equally to the language of
Yes.
section 33 2A? So we're focusing, you say we're focusing on...
Let me just look at it, my lord, because I don't want to sort of say something out of turn that I'm missing. But pad 6. So it's 33 2A. Yes.
So
I-
you've emphasised the words "from the United Kingdom"
Yes.
in G. They don't appear in section 33.
No, I think that though is covered actually in a sense in paragraph 32. I think of it is of MS Palestinian territories, because I think what's there is just the sort of, if one can say, conventional convention question. It's not, and that's so where you see that wording, removal would breach a person's convention rights. What the court's saying in MS Palestinian territories is that doesn't mean you look at the destination of removal. You go to that final end of the whole process. You just look at.
So the
what
submission
you know.
is, here the person is here, removing them from here would be, the only relevant question is whether removing them from here would be a breach of the international obligations of the state under the Refugee Convention or the Human Rights Convention.
Yes.
Yeah.
and it's for those cases where you can decide it, as it were, on, you know, it's not.
Well, it might.
It doesn't integrate, it doesn't integrate the destination of removal, I think, is the clearest way of putting it, and that's really what MS
But the
Palestinian
facts might all be
territories.
agreed, so you can make a determination at the time because there's no argument about what might happen.
Yes, perhaps an easier way of putting it is to look at the cases where it's actually, you know, removal from the UK in the sense. So it's you've got your private family life here,
Right.
you've got some dependency, maybe even the cases of being at the end stage of a serious illness that means it would accelerate your death. So it's the sort of removal from idea rather than the removal to point. But I think the main point is just that the Court of Appeal on MS Palestinian Territories rejected all this complication. They said just keep it simple, look at the immigration decision at the time, and you just look at the sort of simple convention question, really, about protection. You don't look at all the ins and outs of where you'd remove to and lawfulness removal directions and all of that. That's not integrated into the decision under appeal, so the appeal tribunal or court doesn't have to look at those questions, because they just don't come in under this type of wording. So it doesn't come in under the exemption, the statutory exemption. And that is, I think, the gist of paragraph 32 of the MS Palestinian Territories decision.
32.
Yep. There's a lot in that decision, as it were.
Oh,
So,
the long paragraph.
But
Yes. Yes.
it's
Yep.
a long. I think the beginning bit is just all the reasons why the
Yes.
court says, but
Yes.
it's sort of finding is if I.
Yes. Thank you. So ground 2.
Ground 2 is a consideration of the upper tribunal's application of RARR. I think the first point hasn't really been emphasised today, and that's just picking up the fact that if I show you the points, my lords, if you look at the on page 59 in the core bundle, which is the tribunal's decision at paragraph 33. I think it's actually a typo, and I'll say why I think it's a typo. But you can see that he says 1E or G, and it should have been C or E. In this is a kind of not in accordance with the law kind of point, which crops up under C and E, rather than a removal question per se. Because the argument here is not about removal; it's quite the opposite. It's about not being able to remove. Well, I'm not sure it's exactly the opposite actually, but it's the consequences of not being able to remove and having a deportation order in place. So the first point, my learned friend hasn't lent on it too heavily, is just that, well, he's obviously thinking about the wrong thing because he's put G in there. But you can actually see when you read the RARC analysis, he's not at all thinking about removal from the UK. He is very clearly considering a circumstance where there's, in my learned friend's argument, no prospect of removal. So it's purely semantic. And in fact, I'm not sure it is a good point because if you look at the beginning, there was an issue about whether, because of this court's decision in the previous appeal, it was really open to my learned friend to start arguing about the lawfulness of the deportation order or deportation decision, because it had been held to be lawful to make the deportation decision. And so there was an argument about that, and the judge considered that and said no, that these points can be run. And when the judge looked at that, you can see that he actually there does say it's clearly E. So it's paragraph 74 of the Upper Tribunal's decision. And you can see that there he understands that it's not in accordance with the law point in respect of sort of challenging the making of a deportation decision or deportation order on the basis that it can't be effected and say it leaves the person in limbo, which is the gist of the RA Iraq argument. So you can see he's got it right in 74, and I think it's just a slip when he does the summary thing in the last bit of that at the end. There's certainly no evidence of him looking at G anywhere in the analysis. It's always not in accordance with the law, which appears under E and is the argument under C. Even if he did make that slip, in my submission it's not a material error of law, so it is what it is. It's not grounds to set aside the next point is that the judge was wrong to not distinguish RA Iraq on the basis that in RA Iraq there was sort of a slight prospect of removal, but it's my learned friend's submission that here there really is no prospect of removal. And he said that's what the judge's findings were. But it then gets transmuted into no prospect of any deportation anywhere on the judge's findings. And in my submission, it doesn't, the judge's findings do not support that interpretation of his decision. So if we look at the tribunal's decision, starting at paragraph 101, I'm sure you've read the whole thing, so I'm not going to go over all the ins and outs of why the judge came to the conclusions that he came to, but I'm going to start with the sort of summing up of his conclusions on the evidence before him.
Yes.
A key finding at paragraph 101 on page 54, taking into account everything that goes before, and viewing his evidence in the round with other material, I find that PA's evidence is not something on which I can safely rely unless confirmed by independent material. Paragraph 103, having heard the appellant and considered his evidence as a whole, I am not, giving my findings on his credibility, satisfied that he has given all the information available to him. And you'll see he says he considers it's unlikely, if the information was correct, that the Secretary of State wouldn't have been able to verify it with either the Portuguese authorities or Jamaican authorities. What comes next at 104 is taking into account this concession, and it's this concession that my learned friend relies on, where the poor old presenting officer said that the PA wasn't Jamaican, and that's one of the sort of main planks of the appeal. This is where the judge puts that in context, and you can see in 105 and 106 there's doubt about, and there is nothing to support PA's account as to being Portuguese national and as to having a Portuguese passport and using that to come to the UK, and then that being taken by the police and lost, and which is the underlying account for him being here in the first place without any leave, and not being able to depart if a deportation order is made against him, that he would be unable to depart because he hasn't got a passport and can't get one on his account. So if we go on to 109, the judge there considers the impact of the concession on the appeal and says, well, what is the impact of this? That he's neither Jamaican nor Portuguese. He says, yes, these can be, because they're matters of foreign law, they can be findings of fact, but there is no concession that the appellant has been truthful or has fully complied in providing all the information available to him. And so the judge's finding is that there is still information out there that's relevant to this question. So on the facts before him as of the time of the appeal, he couldn't say that there's a prospect of removal to Jamaica or to Portugal. But he's not saying you then equate that with no prospect ever of any deportation anywhere. It's all yet to be revealed, because if the individual does have a nationality that isn't Jamaican or Portuguese, then there's nothing to show that he wouldn't be able to have a passport if he hasn't got one already, and either leave or be enforceably removed to that country. So it just isn't there. This construction that my learned friend's trying to make about this is the findings of this appeal mean there is no prospect of ever deporting the individual anywhere. It isn't supported. And so even if it's not phrased terribly well by the judge, he just doesn't have the basis upon which he could make sustainable findings as to the future. And it's difficult enough in normal circumstances, but here where you know there are pieces of information missing. And there is actually a decision of Miss Justice Ailes, as he then was, that points this out in a case called MS, which I think inadvertently was left out of the bundle. But it's a simple proposition that where you know or have reasonable suspicions that all the information isn't available, it's reasonable to consider that with that, the reason that information is being suppressed is because it would be useful and it could change the circumstances. And so that's a reasonable situation. And it's really not a high threshold one has to meet, because all one has to show is that there's room for change, you know, that this is not immutable. And so there just wasn't a factual scenario before the judge and on his own findings that said, this, we know it all now, it's all sorted out, and it's immutable. And it means no deportation ever anywhere. So those are the findings that one has to sort of bear in mind when considering the distinction that my learned friend seeks to make between RA Iraq, where it was accepted there was sort of no prospect of removal, little prospect of removal, and this case where he says here it's all clear and there's absolutely no prospect of removal, so therefore you must say there's no public interest in a deportation order. And that is relying on a consideration of RA Iraq itself, and I gratefully accept the point of my lord that it's putting quite a lot of strain on paragraph 72 of RA Iraq to say that what the court was really saying there is you progress from no, in all cases where there's little, you know, as the prospect of removal goes down, the public interest goes down, you extrapolate from that automatically, if there's no prospect of removal, there's no public interest in a deportation order, because that wasn't said. And and that's a very stark thing to say, because the deportation order, as the court comes on to say in some of the other parts of the judgment, but anyway, the judge finds, and it's very clearly part of the essence of a deportation order, is it does other jobs, that it's not just about enforcing removal. As I say, at the moment we're seeing it in the case of Russian foreign criminals, that if they're leaving the UK, if there's a deportation order in place, then they can't return. You know, there's the exclusion order bit of it. Now, in some of those cases, it's been said, oh, they could never leave the UK because they've fallen out with the Russian regime, they can't go back to Russia, etc., etc. But the facts are transpiring that some people are able to leave and have lived. So it is not possible in this type of scenario to say never. You know, it's always never. And that's not been the approach of the courts either. And you see that in cases like George, that I'll come on to later, that it's not as clear cut as all that. So you can't remove the public interest just because at the moment it doesn't look like there's a prospect of removal to Jamaica or to Portugal.
Does Baroness Hale's observation in Kadir come into play at this point in the argument?
I mean, the interesting thing is that Kadir is about detention.
Yes, it is.
So, and detention is a special world of its own.
It's the observation, if right, and we have to assume it is, would have wider significance. But she says that there might come a time where the prospects of either voluntary or compulsory departure are so remote that it would be irrational to deny a status. There's a possible link there.
Yes.
But I thought that might be what Lord Justice Haddon Cave was referring to when he said in 71 C above, I think it's something like that.
Yes, I mean it is that.
COR, yes.
It is that. There's been this sort of tantalising sort of we're not going to rule it out sort of
No.
statements, but it's quite
It's certainly not
elite.
unequivocal.
It's quite elite because
Yeah.
this really all comes. I mean, you might do it under rationality, or you might do it under Article 8, as it were. But even the Court of Human Rights hasn't gone that far in Article 8, saying if you sort of manage to obstruct removal for long enough, or in some way, then you get leave, because everyone understands the destructive effect that would have on people's lives.
Well, that may be why Baroness Hale mentioned voluntary departure, because she
Yeah.
wasn't saying you can obstruct it for so long that the Secretary of State is forced to give you a status.
Yeah.
She was saying something different.
But what's clear is it's an idea of not ruling out the possibility. It's absolutely not saying the opposite of that, which is that in that circumstance it will always be the case. There will be no public interest, or there will be no rational basis for making a decision, or there will be, all the court's really floating is that, that a time might come, it might be that situation. And my submission is, well, whether or not that's, been made out, and you'll see that Lord Justice Haddon Cave does go through all those sort of references and looks at it all, and looks at whether there's any policy basis, whether there's any, what is there to support this idea, which is really quite radical, that it's the fait accompli idea, really. And, that you create a situation, or a situation is there where you have to give leave to someone who doesn't have any right to leave under the immigration rules. There's sort of democratic consensus that says we give leave to these people in these circumstances doesn't apply to you. You've got this sort of purpose in being in the UK, that's identifiable under those. But you have to be given leave to remain because you're here, and you can't be removed enforceably on the information available. That's really quite a turning round of a situation. And so...
Yes, but the Secretary of State appealed a case which was heard last week, called AM Belarus, in which that issue did arise.
Yes, I mean, I'm not saying it's not around as an issue. What I'm saying is, at the moment, there isn't anything at the time of this decision in front of the tribunal that said what my learned friend needs to be said, really, which is that, if you can create a situation in which there is no prospect of removal, that means that you cannot have a deportational decision made.
Well, it depends. The upper tribunal judge in that case had decided that position had been reached.
Yes.
That was on the facts of that case.
And as I say, sometimes it's more to do with Article 8, actually. And there's an issue there, and that came up here with the tribunal decision that was relied on here, because the tribunal decision in that case had looked at Article 8 negative obligations, actually, which is not how it should be dealt with. It should be under the positive obligations, because the negative obligations are removing someone. I know, my lord, that but the negative obligations.
Well, that argument was raised in that case. It became, during the course of the hearing, form rather than substance.
Right. So yeah, exactly. I mean, that is the problem with all these arguments, and that's why arguments in this appeal about form, which section, how is it put, whatever, are particularly difficult, because a lot of these things collapse into the same sort of ideas, even though they might be put under a particular section or a particular formulation or analysis. It's a lot of them are themes that are actually broadly similar, not in accordance with the law. So it's coming under E, it's coming under C. There are several different arguments under, so as I say, it is quite hard, I think, to compartmentalise all this and sort of say, and that's why perhaps those arguments don't appeal to a court, to say, well, it's this and not that. So, as it is, though, my learned friend wasn't able to show that the judge was sort of wrong not to distinguish this case from RA Iraq on that really quite a fine distinction between very little prospect of removal and no prospect altogether. Because however the judge worded some of the sort of bits of his judgment, his essential findings are that it's not a case of certainty, where you can say there'll never be a prospect. Perhaps it's never, rather than no prospect. You can state the current position of no prospect, no foreseeable prospect, but it's turning that into never. So you can never be removed, you can never, because there could be sort of changes of circumstance or development. So the point that's being argued about RA Iraq in my submission isn't made out. And the judge didn't err in his consideration of it. Of course, RA Iraq was was all considered on the basis that my learned friend was sort of arguing about the use of a deportation order as a means of regulating the person's stay in the UK, as it were, and preventing them. I think that it is quite a difficult fit to a Section 32(5) immigration decision. In RA Iraq itself, because the individual was a minor when the deportation decision was made, the automatic deportation order didn't apply to him because he committed the offence before he was 18, and so he wouldn't be under the automatic deportation regime. And although he later offended, they stuck with the same. He was still appealing the deportation provisions. So it was a J, not a 3A case. Whether or not the judge is right to consider it all at all or whatever, I say he is, because I think it's better to deal with these matters and say, well, even if all this does apply, I'm applying that analysis, and it doesn't make it unlawful, not in accordance with the law. But I simply just flag that up, but it's not as good a fit with a 32(5) decision, because it's not a decision to make a deportation order.
Well, I thought
Yes,
your
Nick.
submission effectively was that it doesn't apply
Well,
because of the limited basis on which you can challenge a Section 32(5) order.
my submission under Appeal Ground 84(1)G is that the removal directions, that's the looking at the removal end
I
of it.
understand.
This is a different aspect of not in accordance with the law, in
Yes.
effect, which is you can't do this because the effect of keeping the person in the UK without giving them leave or without
Yes.
giving them, because the deportation order means that you block, them sort of getting leave and moving through, on remaining in the UK, sort of firming up their status in the
Yes.
UK. And so it's a different aspect of not in accordance with law. And I am just flagging up that consistently with my submissions as to the limitations of a 32(5) decision, you might say it's questionable whether RA Iraq applies here, that type of analysis here. But the judge was correct, I think, to consider it in my submission and to deal with it and say, well, it wouldn't make any difference here
Yes.
anyway.
Yes.
So I just wanted to flag up that point for consistency, because we don't want it going up and down, because it said
Yes.
it was relevant and then the judge didn't consider it. And he looks at it under not in accordance with the law as well, under C, because, as I say, some of these points are made in different forms under the different appeal ground headings, because we had quite a lot of appeal grounds going on at once. Some of them did fall by the wayside. You're not getting the full lot up here. But so in my submission, the judge was right to basically follow, insofar as that argument's being run, the judge was right to follow RA Iraq in dealing with that argument and running through the four-stage analysis and applying it to the facts of the case. And he was entitled to come to the conclusion he came to at the end, which is the balancing up conclusion. So in a way, he's sort of given the benefit of a doubt to the appellant all the way through, as it were, and he comes to the final stage, that you get to the final stage.
Yes.
And even at the final stage, he says, no, there still remains this
Yes.
significant public interest in deportation. And in my submission, there is a clear public interest in deportation, and this comes into appeal ground 3, which deals with not in accordance with law, but does it on the basis that you can't have a deportation order lawfully if you can't say at the time you will be able to deport a person to that country. If, to the contrary, on the current information, you won't be able to enforce their removal. And there's a point made in the skeleton argument, it's not really pursued about, well, the judge dealt with this under a different heading, but because, as I say, a lot of the similar points come up, because there's an Article 8 element to this, it's quite proper to, you don't have to repeat Article 8 analysis each time. So it's quite proper for the judge to refer back to the bits of the judgment that have already dealt with the same question. And that's my paragraph 15 in the note. And that seems to be accepted even in the appellant skeleton that it was dealt with, even though he didn't get the right conclusion on it. So picking it up at paragraph 16, the appellant doesn't dispute what the judge says about the role of a deportation order in these two statutory schemes, and that's the automatic deportation regime, which is different. You know, it's there for a particular purpose, which is to make sure there is a deportation order, and the appeal scheme, and the section 117 2002 legislation, which also deals with this same question of whether there's a public interest in deporting a foreign criminal. And so for the second time, Parliament deems very clearly that there is a public interest in deporting a foreign criminal. So irrespective of all your difficulties that you might have in effecting deportation, you can't say there's no public interest in deporting a foreign criminal, because Parliament has very clearly said that twice. And it's not just the deportation itself, it's making the deportation order, or having a deportation order in place. And obviously a deportation order is multifaceted, as we said. It's a direction to leave the UK, and it's an order to enforce removal if there's no voluntary departure. And it is in accordance with the law, because there is a purpose to that. Paragraph 16 sets it out, that the Supreme Court in Nationality looked at the genesis of the automatic deportation regime in the white papers, and there is a public consensus that deportation of foreign criminals is important and ought to be effected, and a concern that there isn't a sort of recognition of the importance of that, and that's part of what making the deportation order does. It was once, I think there was a sort of rather old-fashioned sort of phrases associated with it, but I think the essence of it is that it's an expression of the fact that this matters, that if you committed crimes in the UK, that does put you in a different category to somebody who hasn't come here and committed crimes in the UK, and that is an additional reason to enforce. So it's not just immigration reasons for removal. You haven't got leave to remain, you never had leave to remain. It's also this additional factor that deportation carries to mark out that this person's a foreign criminal and there's a particular public interest in doing it. And as I've indicated also, of course it stops you coming back if for some reason you do leave the UK. So there are other elements to it. It's not just about enforcing removal. And none of those are taken into account in my learned friend's submission, because his submission is that all of this is about whether you can set removal directions to Jamaica, and you can't, and therefore you can't make a Section 32(5) decision that is anything other than Section 33 applies. And it's just loading far too much in my submission on this type of appeal, this narrow type of appeal, that really, if one applies to revoke a deportation order, you can see that those submissions fit much better into this is the effect of maintaining it in these circumstances, etc., etc., etc. But assuming that you can look at it in accordance with the law in this way, which I say is probably not appropriate, you can see it's not a good point anyway. So, in the circumstances of this case, and the judge was right and can't be faulted for rejecting it for the reasons that he gave. And they appear, paragraph 134, page 59 onwards. Paragraph 137, he says, and this is about the improper purpose argument. There's a Padfield argument about the only reason you've got the power to make a deportation order is to enforce removal, and therefore if you can't enforce removal, you can't make a deportation order. And he says, no, I don't. But you can see the judge is quite mindful in 137 and saying, you know, you can't argue anything in this appeal under these not in accordance with the law ground. You know, it is conditioned by what he says in paragraph 134, that this is a Section 32(5) appeal, and that limits the type of, it's not a decision to make a deportation order. and so all your arguments about why you shouldn't be making a deportation order can't really apply here, because that's not the actual decision that's under appeal. And there you can see that he rejects it anyway on its merits. And that point applies equally to the Katie argument about extrapolating back on whether you can have someone on bail and using whether or not you can detain someone as a reason not to be able to make a Section 32(5) decision. Because if you accept that the scope of the appeal under Section 82 was a limited scope, a limited type of decision, then these sort of technical arguments about public law errors, really, in making a deportation decision or a decision to make a deportation order, just don't really stick, because that's not the decision you're making. Under 3A, the decision you're making is just that: is there a convention reason why your removal would be a breach of the convention? So the sort of whole edifice of getting all these other complications in just doesn't work in this type of appeal. And there's no need to overcomplicate the appeals by doing that, because you can run arguments like this on judicial review or revocation decisions or what have you. You don't need to confer on the poor old first-tier tribunal, most of whom aren't legally qualified, all the complications of public law errors not in accordance with law in this kind of sense, when considering what is quite a narrow appeal right. The only other point I want to just make is that although these complicated appeal rights and grounds have been swept away by years ago now by the changes to the appeal structure, the basis for the grant of permission in this case was that I think it's hard, but I think it's the in accordance with law bit coming in. I think that was the bit where it's envisaged it might come into the new appeal rights, because if you accept that reference to a breach of the convention includes, because you're referring to Article 8, not in accordance with law, as it were, in respect of anything. So rather than sort of Article 8 narrow on the decision that's being made, but anything in relation to the sort of, saying these things are integrated into the decision. So if you can find a bit that's not in accordance, that has a public law error in it, this is the Abdi point, then you can sort of unravel the whole thing. I submit that's not right, but this case isn't the right way to consider whether that's right for the purposes of the new, not I don't say new, but the existing appeal grounds, because the existing appeal grounds are confined to protection claims. They are. So it's not just any immigration decision can be challenged on a not in accordance with law basis. It's now confined to protection claims. But my learned friend's argument could conceivably encompass that, because it's said under Article 8 that not in accordance with law comes in, and then you start to look at any sort of public law error. And in my submission, it doesn't work in this case because it's a 32(5) a case, but in any event, I'd ask the court to say that it's not an appropriate case in which to consider this matter generally for the purposes of Article 8 or the new appeal or the current appeal system.
Yes.
And really, it wasn't all that my laws were really shown was Abdi and ZH Tanzania, which is very limited sort of idea. And Abdi is, of course, a general. It's not a 32(5) type of appeal right, as it were. It just makes a general proposition that not in accordance with law can include a public law error in the decision that's being challenged. So it's there, not expanding it out to say any possible decision related to, it is just if there's a clear public law error in the decision that's challenged, then that can come in, that type of public law error can come in under not in accordance with law. It's part of the reason it was so complicated. And the ZH Tanzania doesn't really add anything in my submission that's material to this case. Either way, it's simply an indication by the court of certain things, but it's certainly not justifying rewriting the statute and the scope of the appeal. And if one was to consider what was in accordance with the law for Article 8 purposes in the context of deportation, that is conditioned by what Parliament has said about it, and what Parliament has said about the public interest, what Parliament has said about what you analyse when you're doing the Article 8 analysis, and how you strike the balance. Although it's always to the court to strike the balance,
Yes.
clearly
Yeah.
that's the approach you take to it. You don't do this sort of approach that my learned friend is suggesting of, is there a public law error, or is there a for a convention argument of not in accordance with law. It's my submission that really you look at whether on the Masco analysis you're really looking at whether there's a lawful right to do something, so that's the sort of is this being done in a lawful way sort of situation, and then you're looking at proportionality. So it doesn't import in necessarily this sort of wider idea of public law errors. So unless I can assist further, those are my submissions.
No, thank you very much. Yes, Scoburn.
Ms. Mellows, I'm only going to reply on 2 points. The main point I want to reply on is the question of section 84(1)(g) and section 33(2)(a) and the proper interpretation of those sections. From a learned friend, her argument was that the use of the word relied on the use of the word "from" in 84(1)(g), and so that the appeal she submits is concerned with the lawfulness under the Human Rights Convention as incorporated in removing a person from the jurisdiction, and is not concerned with the destination to which they are removed. The first point on that is that it's inconsistent with the statutory provisions, because both 84(1)(g) and section 33(2) refer first of all to the Convention, the European Convention on Human Rights, and secondly to the Refugee Convention. And under both of those conventions, it's necessary to look at the destination, because a refugee is only protected. The whole purpose of the Refugee Convention is to protect a person from refoulement.
I think the submission is, sorry to interrupt you, I think the submission is, when do you look at the destination? As I understood the submission is that we're not at the stage when the destination forms part of the decision that's under challenge.
Yes. So let me just take that point in one moment, just finish off the statutory interpretation point, because I understand that. What the legislation then is concerned to ensure in the appeal right, 84(1)(g), and in the section 33(2)(a), is to ensure that in the appeal succeeds where removal to that destination would infringe. Let's start with the Refugee Convention, where it would breach the Refugee Convention. Now, you can effectively only make out a claim that your rights under the Refugee Convention would be breached by reference to the destination of the proposed removal, because it's only on the return to the refoulement to the country of origin that your Refugee Convention rights would be infringed. So you have to have a destination for any Refugee Convention claim. Similarly, any Article 3 claim that you will be subjected to inhuman or degrading treatment on return is only made out on the basis of which country you're being removed to. So that's inherent within that. Now, as to the point of when do we get there? Well, that in my submission can be answered very simply. If if not in the appeal, when? Because the appeal is the structure that is set up to determine the questions of fact and law that arise in relation to that question. Now, what's implicit in Moylan and Friends' submission is, if you don't address it in the appeal, is that you address it at some subsequent stage. But when would that be? If this appeal fails, the premise of having made the decision, the immigration decision, is that the appeal failing, he will be removed. So what does he do? He brings a judicial review and says, well, my appeal failed last week, but we didn't look at the question of whether it would actually infringe my human rights or refugee convention rights to go to Jamaica. So now can I have another go? I mean, it doesn't make any sense in terms of the structure of the appeal system being the very system that is designed to ascertain whether the decision would breach his human rights.
I'm so sorry to interrupt. I hope it will be a helpful intervention. Just to say that I accepted that the convention claims, as it were, can be made in this. It's just the removal directions under the schedule point that I say isn't integrated into the decision.
So that's why, for the last 20 years, appeals in the tribunal are concerned with the lawfulness of removal, and that concerns, in almost all cases, a destination, or a proposed destination, if I put it more neutrally in that way, as proposed by the Secretary of State. And indeed, in this case, if one looks at the actual decision that was under challenge, it specifies quite explicitly what destination the Secretary of State proposed, pursuant to the Immigration Notices Regulations that were then in place, the Immigration Notices Regulations 2003, which required the destination to be stated in the notice. So that is why Jamaica is stated, because it was a regulatory requirement. When it came to the actual appeal in question, if one looks at the determination by the judge at paragraph 45, the court will see that the Secretary of State's position was that he was Jamaican and would be removed there. So at 45, it summarises the submission of the Secretary of State. With regard to his Jamaican nationality, Ms Anderson submitted this was a matter of law, relying on A.S. Guinea and a case called in Armo. Ms Anderson submitted the appellant's mother was Jamaican, and as a matter of law he was entitled to nationality based on his mother's nationality at birth. She accepted that plainly there would be cases where that information could not be produced, but that the appellant ought to be able to produce them. And the judge then goes on to consider at 48 and 49 further submissions of the Secretary of State. But the premise of the appeal before the judge in this case, on the facts of this case, was the Secretary of State maintaining the position in the immigration decision under appeal that he would be removed to Jamaica. And that is why the judge addresses those issues in his determination on the points of principle, when he says what would happen if he got returned to Jamaica and it wouldn't breach his Article 3 rights. It's because that was what the Secretary of State said she would do if this appeal did not succeed. Now, the fact that he succeeded on the ground that he cannot be deported there was because his argument succeeded. But what the Secretary of State now does is completely shift the ground. This argument that, in fact, all that needed to be looked at was the principle of removal without any destination in question, was not an argument made to the tribunal, and indeed it wasn't an argument made to this court until today. It's not prefaced in any written pleading for the Secretary of State. And so the tribunal has to simply deal with the arguments in front of it. Where a destination is proposed by the Secretary of State, simply as a matter of fairness and propriety, both to the appellant and the tribunal, that's the case the tribunal deals with. The argument now suggested that it should have addressed this in-principle question was nowhere in the Secretary of State's case before it. And so, to come back to the question that the destination is not an integral part of the notice, doesn't answer the problem of how the appeal is to be determined. Because the appeal is not just looking at the validity in a superficial sense of a notice that doesn't have to specify destination. The appeal, as section 33.2a and section 84.1g demonstrate, is concerned with the consequences of removal pursuant to that decision. Now, it is conceivable to envisage a case where the Secretary of State might say, I do not know where I'm going to remove, and then an appeal will proceed on that premise. But that's not our case, and we don't have to hypothesise about that. This was a case where the Secretary of State was absolutely clear that removal was to Jamaica. So that's my submissions both on the legal position as to what's required on an appeal on an 84.1g ground, and as to the factual position and the fairness of the new stance taken today by my learned friend. The only other point I wanted to reply on was that a short point really, that the Secretary of State says the language of the way in which the appeal works is that it's against the decision that the Section 32(5) duty applies, and the Secretary of State says that even if you succeed in establishing that, you can still make a deportation order on a discretionary basis. It's simply you're not obliged to do so. But on a very narrow basis, that may well be true. The Secretary of State is not obliged to make a deportation order. Nonetheless, as a matter of discretion under Section 5 of the Immigration Act, he can still do so. But that point has already been determined by the Court of Appeal in Mr. Antonio's case, which at paragraph 79, I believe it is, his is tab 17 of the bundle. 72, it's paragraph 72, and the court will recall that the proceedings were alleging that where the Secretary of State revoked a deportation order, the Secretary of State couldn't simply make a new one, and the answer to that the court put was, in acting in that fashion, making a second deportation order, the Secretary of State may not be acting under the compulsion of a duty under Section 32(5), but she will be acting in a way consistent with the clearest public policy expressed by Parliament. So we already know that the duty doesn't apply because this is a second deportation order. And so the narrow point made from my learned friend that, oh, well, if the duty doesn't apply, you've still got the discretion. That's a very narrow point because it only survives where there's not some substantive obstacle to the making of the deportation order. And that's what the grounds of appeal are all concerned with. They are concerned with whether there is a human rights reason or a legal obstacle, whether it's in accordance with the law, to make the deportation order. And so where an appeal succeeds, even though it's against a decision that the duty applies, it doesn't only succeed to the extent that the duty is said no longer to apply. It clearly has a wider extended effect than that to undermine the capacity of the Secretary of State to make a deportation order at all. So those are my only 2 points that I wanted to take in response. Unless I can help me further, I invite you to allow the appeal.
No, Scoon, thank you very much. Thank you both very much for your respective submissions. We will, of course, be reserving our judgments, and they will be handed out in draft in the usual way, which is, as you will be aware, solely for the purpose of correcting typos, not for other purposes, and the drafts must not be used for other purposes, and it would be a contempt of court if they were used for other purposes. And we would hope that once you receive the draft, you'll be able to agree an order, but if not, we will deal with any outstanding matters on the papers. So, thank you very much.
I'm very grateful.
Guys.